Hello friends, my name is Nizamuddin Ahmed Siddiqui and I am an assistant professor of law at West Bengal National University of Juridical Sciences, Kolkata. I will be taking this unit on human rights and duties as constitutional guarantees on behalf of the content writer Dr. K. Sita Manikayam, assistant professor, Dr. B.R. Ambedkar Law College, Andhra University. This unit will aim to fulfill certain learning objectives, which include number 1, understanding the human rights and human duties dichotomy. Number 2, understanding the general connections between constitutional guarantees under the Indian Constitution and the Universal Declaration of Human Rights, 1948. With these objectives, let us start. The preamble to the Indian Constitution declares India to be a sovereign, socialist, secular, democratic republic. The term democratic denotes that the government gets its power from the will of the people. It gives a sensation that they are all equal, irrespective of the race, religion, language, sex, and culture. It further pledges justice, social, economic, and political, liberty of thought expression, belief, faith, and worship, equality of status and of opportunity, and fraternity, assuring the self-esteem of the individual, and the unity and integrity of the nation. Many civil and political rights, such as the right to equality, freedom of speech, right to life and personal liberty, the right to free primary education, right to practice and propagation of religion, etc., are provided as fundamental rights under the Constitution. Many economic, social, and cultural rights, like the right to education, health, and work, have been provided under the provisions of directive principles of state policy, which are fundamental in the supremacy of the country. The legislative body has enacted a range of legislations which seek out to protect and promote the right of the susceptible sections of the society, like the disabled, the scheduled castes and scheduled tribes, women, and children. As far as women are concerned, the legislations wrap issues such as dowry harassment, immoral traffic, prevention of sati, and female feticide. The Universal Declaration of Human Rights, proclaimed by the General Assembly on 10th of December 1948, constitutes a significant event of the first enormity. It was an encouragement for all the states to value certain basic rights. The rights incorporated in UDHR and the other two covenants, civil and political rights and economic, social, and cultural rights covenants, are binding on those states which are parties to the treaties. Most of the human rights in Universal Declaration are also integrated as fundamental rights in Part 3 of the Constitution of India. The Constitution was adopted on 26th of November 1949 and came into force on 26th of January 1950 as a matter of fact. It is generally observed that the civil and political rights are protected under Part 3, whereas the economic, social, and cultural rights incorporated under Part 4 of the Constitution are not enforceable. The fact that Part 3 is made enforceable, but Part 4 is not. However, the fact that Part 3 is made enforceable while Part 4 is not enforceable highlights the deviation from international standards, where such distinction in enforceability of civil and political rights and economic, social, and cultural rights is not found under the covenants on human rights, except that the Economic, Social and Cultural Rights Covenant is said to be programmable in nature. Also, non-enforceability of Part 4 does not stand for a malified intention on the part of the government. The Constitution of India guarantees fundamental rights which can be classified into the following categories: right to equality, Articles 14 to 18, right to freedom, Articles 19 to 22, right against exploitation, Articles 23 and 24, right to freedom of religion, 25 to 28, cultural and educational rights, 29 and 30, and right to constitutional remedies, 32. The just understanding and appreciation of the extent of human rights standards incorporated in the Constitution needs consideration of the International Bill of Human Rights. For this purpose, the optional protocols 1 to the Civil and Political Rights and Economic, Social and Cultural Rights Covenants have been excluded as they deal with specific procedures relating to individual communications. Optional Protocol 2 to the Civil and Political Rights Covenant is also excluded because it deals with abolition of death penalty, which India has not ratified. The discussion in this unit will be on the extent of human rights standards incorporated under the Constitution of India. And we will start with the examination of civil and political rights, followed by the economic, social and cultural rights enumerated in all the three instruments UDHR, ICCPR and ICESCR along with the Constitution of India. The UDHR, among others, guarantees the right to life and liberty under Article 3. ICCPR, as an improvisation to the said right, guaranteed by the UDHR, provides for the inherent right to life that cannot be arbitrarily deprived. According to the ICCPR, right to life is to be protected by law, and any penalty affecting life can only be carried out pursuant to a final judgment rendered by a competent court. Further, persons sentenced to death have the right to seek pardon or commutation of the sentence. Therefore, amnesty, pardon or commutation of the sentence of death may be granted in all cases. Most importantly, the ICCPR holds that while awarding a death sentence, due recognition to the tender age of the person and motherhood must be given. And in fact, it goes to the extent of declaring that the sentence of death shall not be imposed for crimes committed by persons below 18 years of age and shall not be carried out on pregnant women. In India, the right to life and liberty is expressly recognized under Article 21, and the provision for seeking pardon or commutation of the offence as provided by the ICCPR is recognized under Articles 72 and 161 of the Constitution, which empowers the President and the Governor respectively to grant, pardon, commute, respite or remit the sentences. As to the right against sentence of death for the crimes committed by persons below 18 years of age and pregnant women, the Constitution does not expressly protect these rights. However, the Code of Criminal Procedure 1973 gives recognition to the right against sentence of death of pregnant women. The Juvenile Justice Care and Protection Act protects the case of persons below the age of 18 years from imposition of death penalty. A right against slavery or servitude guaranteed by UDHR includes its prohibition in all forms. In India, Article 23 of the Constitution states that traffic in human beings and begar and other similar forms of forced labor is prohibited. However, this provision in the Constitution does not make use of the expression slavery or servitude, as mentioned in the International Bill of Human Rights. Forced labor and begar in a wider sense therefore may be considered as a species of slavery. UDHR provides for equality before the law and equal protection of law without any discrimination. This right is protected by Article 26 of the ICCPR, which in addition states that this law shall prohibit any discrimination and guarantee to all persons equal and effective protection against discrimination on any ground such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth or other status. In India, Articles 14 and 15 of the Constitution recognize the right to equality before law, equal protection of laws, and right against discrimination. The right against arbitrary arrest and detention is also recognized by the UDHR. In India, a joint reading of Articles 21 and 22 would suggest that most of the rights provided against arrest and detention are also recognized under the Constitution. Besides, Sections 50, 50A, 56 and 57 of the Code of Criminal Procedure 1973 supplements the conferrals found in the Constitution. The UDHR states that everyone charged with a penal offence has the right to be presumed innocent until proven guilty according to law in a public trial at which he has had all the guarantees necessary for his defence. No one shall be guilty of any penal offence because of any act or omission that did not constitute a penal offence under national or international law at the time when it was committed. Nor shall a heavier penalty be imposed than the one that was applicable at the time the penal offence was committed. Under the Constitution of India, there is no express provision to consider a person as innocent until his guilt is proven. Nevertheless, the courts in India have been referring to the international human rights instruments and giving effect to this rule. Article 22(1) and 4 safeguards the rights of the arrested persons, and Articles 20 Clause 1 and 2 of the Constitution protects convicts against higher penalty and double jeopardy. Article 13 of the UDHR states that everyone has the right to freedom of movement and residence within the borders of each state. Article 12 of the ICCPR states that everyone lawfully within the territory of a state shall within that territory have the right to liberty of movement and freedom to choose his residence. Everyone shall be free to leave any country, including his own. Article 12 of the ICCPR also provides that the rights guaranteed by it shall not be subject to any restrictions except those that are provided by law or as are necessary to protect national security, public order, public health, or morals, or the rights and freedoms of others, and are consistent with the other rights recognized in the ICCPR, and that no one shall be arbitrarily deprived of the right to enter his own country. In India, Article 19(1)(d) and E of the Constitution recognizes the freedom of movement and residence, which may be restricted in the interests of the public and for the protection of the interests of any scheduled tribes. under Article 19, Clause 5. These are the limitations. Right to leave the country is not expressly recognized under the Constitution. Article 17 of the UDHR provides for a right to own property alone as well as in association with others. This right cannot be arbitrarily deprived. Interestingly, right to property is not recognized under the ICCPR except as grounds specified for prohibition of discrimination. Whereas Article 300A of the Constitution guarantees the right to property to every person which cannot be deprived save by the authority of law. This recognition is in the form of constitutional right, which earlier was a fundamental right under Article 19(1)(f) that was omitted by the Constitutional 44th Amendment in 1978. According to Article 19 of the UDHR, everyone has the right to freedom of thought, conscience and religion, which includes freedom to change his religion or belief and freedom either alone or in community with others and in public or private to manifest his religion or belief in teaching, practice, worship and observance of that religion. According to Article 18 of the ICCPR, everyone has the right to freedom of thought, conscience and religion, which includes freedom to have or to adopt a religion or belief of his choice and freedom to manifest his religion or belief in worship, observance, practice and teaching. This freedom would ensure that no one is subject to coercion to adopt a religion or belief that is against his choice. Further, the limitations are clearly laid down in the same provision, according to which the freedom to manifest one's religion or beliefs may be subject only to such limitations as are prescribed by law and are necessary to protect public safety, order, health, or morals. In addition, Article 27 of the ICCPR guarantees ethnic, religious, or linguistic minorities the right to enjoy their own culture, to profess and practice their own religion, or to use their own language. In India, Articles 25 to 28 of the Constitution recognize the freedom of religion, which is subjected to public order, morality, health, and other provisions of Part 3 of the Constitution. Indeed, Articles 29 and 30 of the Constitution are the corresponding provisions for Article 27 of the ICCPR. Articles 19 of UDHR and that of the ICCPR confer the right to freedom of opinion and expression, where the latter adds right to hold opinions without interference. Under the Constitution of India, Article 19(1)(a), the freedom of speech and expression is guaranteed to all citizens. This freedom is not absolute, as it is subjected to reasonable restrictions in the interests of the sovereignty and integrity of India, the security of India and its friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation or incitement to an offense. This has been specified under Article 19, Clause 2. Article 20, Clause 1 of UDHR provides for the freedom of peaceful assembly and association. Similarly, Article 21 of the ICCPR recognizes the right of peaceful assembly. Besides, Article 22 of ICCPR provides for the right to freedom of association with others, including the right to form and join trade unions for the protection of interests. Like Article 21, the freedom guaranteed by Article 22 of the ICCPR is subjected to restrictions that are prescribed by law and which are necessary in a democratic society in the interests of national security or public safety, public order, the protection of moral public health or morals, or the protection of the rights and freedoms of others. In the context of India, Article 19(1)(c) of the Constitution guarantees to all citizens the freedom to form or join association, trade unions, or cooperative societies, which may be restricted only on the grounds of interest of the sovereignty and integrity of India, public order, or morality. UDHR proclaims that everyone has the right to take part in the governance of his country directly or through freely chosen representatives, and that everyone has the right of equal access to public service in his country. The will of the people shall be the basis of the authority of the government that shall be expressed in periodic and genuine elections, which are to be conducted by universal, equal suffrage and by secret vote or by equivalent free voting procedure. The ICCPR not only recognizes the right to take part in governance of the country, but also states that every citizen shall have the right and the opportunity, without any distinctions, to take part in the conduct of public affairs directly or through freely chosen representatives, to vote and to be elected at genuine periodic elections, which shall be by universal and equal suffrage, and shall be held by secret ballot, guaranteeing the free expression of the will of the electors, and to have access on general terms of equality to public service in his country. In India, Articles 325 and 326 of the Constitution deal with elections in a manner that is consistent with the principles of UDHR and ICCPR. Besides, Article 16, which provides for equality of opportunity in matters of public employment, read with Articles 311 and 312 of the Constitution, deals with all India's services. However, the right to vote is not explicitly recognized in the Constitution. Friends, let us now look at the economic, social and cultural rights. Article 1 of UDHR holds that all human beings are born free and equal in dignity and rights. According to Article 1, human beings are endowed with reason and conscience, with which they should act towards one another in a spirit of brotherhood. The latter part of this provision is dealt by the Constitution under Article 51A (e) in the form of a fundamental duty. Article 2 of ICSCR obligates the states to ensure that all measures to realize the rights recognized in the covenant must be taken progressively, and they are based on the principle of non-discrimination. Amongst them, the first happens to be a right guaranteed by Article 3 of ICSCR. It provides that the states must ensure equal right to men and women in the employment of all economic, social and cultural rights set forth in the covenant. Similarly, in India, Article 38(2) of the Constitution holds that the state must strive to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities and opportunities, not only amongst individuals, but also amongst groups of people residing in different areas or engaged in different vocations. Friends, this would suggest that the underpinning on which Article 38 is standing is on the principle of non-discrimination. Article 6 of the ICSCR recognizes the right to work. In India, Article 41 of the Constitution provides that the state, within the limits of its economic capacity and development, make effective provisions for securing the right to work. Article 41 proceeds to address education and public assistance in cases of unemployment, old age, sickness and disablement, and in other cases of undeserved want. Under Article 7 of the ICSCR, everyone has the right to the enjoyment of just and favorable conditions of work. This right ensures remuneration which provides all workers as a minimum with fair wages and equal remuneration for work of equal value without distinction of any kind. In particular, women being guaranteed conditions of work not inferior to those enjoyed by men with equal pay for equal work, a decent living for themselves and their families in accordance with the provisions of the covenant, safe and healthy working conditions, equal opportunity for everyone to be promoted in his employment to an appropriate higher level, subject to no considerations other than those of seniority and competence. Rest, leisure and reasonable limitation of periodic hours and periodic holidays with pay as well as remuneration for public holidays. In India, most of these standards are recognized under Article 39 of the Constitution. Article 8 of the ICSCR recognizes the right to form trade unions and join trade unions of one's choice. This right would help the individuals in promoting and protecting their economic and social interests, which is also recognized under Article 19(1)(c) of the Constitution. Article 9 of ICSCR guarantees the right of everyone to social security. Indian government, in accordance with the directives contained in Article 38 and Article 39 of the Constitution, bear the primary responsibility for developing appropriate system by which it could provide protection and assistance to its workforce. Since the workforce in India is increasing, its protection is aimed by various legislations. The principal social security laws enacted in India are: number 1, the Employees State Insurance Act 1948, the Employees Provident Funds and Miscellaneous Provisions Act 1952, the Workmen's Compensation Act 1923, the Maternity Benefit Act 1961, and the Payment of Gratuity Act 1972. Article 10 of ICSCR holds that special protection should be accorded to mothers before and after childbirth. Article 10 of ICSCR further provides that during such period, working mothers should be accorded paid leave or leave with adequate social security benefits. Children and young persons should be protected from economic and social exploitation. Their employment in work harmful to their morals or health, dangerous to life, or likely to hamper their normal development should be punishable by law. States should also set age limits below which the paid employment of child labor should be prohibited and punishable by law. Further, Article 11 of ICSCR deals with the right of everyone to an adequate standard of living for himself and his family, including adequate food, clothing, and housing, and to the continuous improvement of living conditions, which is recognized under Article 43 of the Constitution. Article 12 of ICSCR provides for a right of everyone to the enjoyment of the highest attainable standard of physical and mental health. States must take steps for the reduction of the stillbirth rate and of infant mortality and for the healthy development of the child. The improvement of all aspects of environment and industrial hygiene, the prevention, treatment, and control of epidemic, endemic, occupational, and other diseases. In addition, states must create necessary conditions which would assure to all medical service and medical attention in the event of sickness. In India, Articles 47 and 48 of the Constitution hold thus that the state would be responsible for promoting public health and for promoting and maintaining clean environment for the people. On recall, it would be clear that Article 12 of the ICSCR, in comparison to Articles 47 and 48A of the Constitution, is specific. This would imply that provisions of the Constitution are either abstract or general in nature, and alternatively, Articles 47 and 48A of the Constitution may be provisions having wider amplitude. Article 13 of ICSCR provides that right to education, primary education shall be compulsory and available free to all. In addition, Article 26(1) of ICSCR states that everyone has the right to education. Elementary education shall be compulsory. Technical and professional education shall be made generally available, and higher education shall be equally accessible to all based on their merit. In India, right to education is recognized in Articles 41, 45 and 21A of the Constitution. Article 15 of ICSCR states that everyone has the right to take part in cultural life, to enjoy the benefits of scientific progress and its applications, to benefit from the protection of the morals and material interests resulting from any scientific, literary, or artistic production of which he is the author. Further, it provides that the states must strive to achieve the full realization of this right, and it shall include those necessary for the conservation, the development, and the diffusion of science and culture. Under the Constitution of India, clauses E, F, H, and J of Article 51A deals with the protections addressed by Article 15 of the ICSCR. As to the extent of recognition given to economic, social, and cultural rights under the Constitution, it is said that the catalogue of economic and social rights in the Indian Constitution is extensive as that of the international instruments, though rights are not enforceable through judicial process. Efforts have been made to achieve some of these rights through legislation. The economic, social, and cultural rights require legislative and executive initiatives. Friends, towards the conclusion, we can therefore say that the Constitution is inspired by the UDHR, and accordingly it has incorporated certain civil and political rights as fundamental rights, and economic, social, and cultural rights as part of the directive principles of state policy. It is a text wealthy in human rights jurisprudence. The fundamental rights cast negative obligations on the state, and the directive principles of state policy imposes affirmative obligations. However, the Constitution and the Act still do not give recognition to certain important international human rights standards, such as right to privacy, right to compensation, right to fair trial, right to dignity, right to livelihood, right to decent environment, right to found a family, right against inhuman and degrading treatment. With this, friends, we come to an end of this lecture. I thank you all for listening with patience.